Good afternoon, everyone, and welcome to the latest of Fieldfisher's Privacy webinar series. My name is Renzo Marchini, and I am a partner in the privacy practice in London. Thank you so much for joining us. Today's webinar focuses on AI governance and is prompted by two recent developments: the UK data protection reform announced by the government and the end of a consultation, and the publication of a final version of the AI toolkit by the ICO. Although we focus on UK developments, this will, we hope, be of interest to a wider international audience. Indeed, we will be touching on the AI Act from the EU. AI or machine learning is increasingly used by all businesses, from manufacturing robots to self-driving cars, from automated investment decisions to social media monitoring. And as use cases increase apace, so law and regulation follows. First up today will be Nuria Pastor, a director in our privacy team here in London. She'll be talking about the outcome of the UK government's consultation on data reform. And as always, when planning webinars in privacy these days, there's a danger of being overtaken by events. Of course, we're going to have a change in government in the next couple of months. So Nuria will be talking about also, amongst other things, what that might mean for the timetable of the data protection reform. And of course, in talking about the reform, she will be focusing on issues pertinent to AI. After Nuria will be Martin McElroy, our own DPO at Fieldfisher and a senior data protection advisor, who will be talking about the ICO's new version of its toolkit in AI. Last, but by no means least, our non-privacy guest star, Chris Eastham, a tech partner who spearheads our emerging technologies practice. And Chris will be considering wider issues in the need for AI governance and the consequences of failure. We will finish within the hour, that is at 5 p.m. Before we come on to the substance, a few housekeeping points about our webinar. Please do ask us questions using the question function on your screen. We will try and take them at convenient points during the webinar, so keep them coming. There hopefully will be some time at the end as well, but if we do run out of time, we will respond to questions posed in writing. Next week, we'll be sending you a copy of our slides and indeed even a recording, which will also be posted on our YouTube channel. So don't feel as if you have to scribble everything down as we go along. A couple of other points: do subscribe to that YouTube channel, do subscribe to our blog, which has a regular set of posts on topical issues. And keep an eye out for webinars over the coming months. So with no further ado, I'm going to hand over to Nuria.
Thank you, Renzo, and good afternoon, everyone. So as Renzo said, I will discuss the data protection reform in the UK. So only a few days ago, on the 17th of June, the UK government published the responses to its consultation, which was launched in September 2021, regarding the reform to the data protection law in the UK. With this reform, the objective of the government, and Renzo, we can go to the next slide, actually. So with this reform, the objective of the government is to create a pro-growth and trusted data protection regime. A reminder that the UK is in a position to amend its data protection regime because it has left the EU. So the current regime is based on the EU GDPR, and in fact, we could say that the UK GDPR is pretty much a copy and paste of the EU GDPR. And the UK government, as part of its broader national data strategy initiative, it's keen to make the data protection regime in the UK more flexible. So what's next? As Renzo mentioned, the party in government in the UK is currently in the process of electing a new leader, and the UK should have a new prime minister and a new government, hopefully in the next few weeks. This means that it's unlikely that the data reform bill will be published before the Parliament's summer recess, which is coming up very, very soon. So our hope or our understanding is that we should see the bill hopefully after the summer or maybe into the autumn. So for our session today, I will focus on two areas of the data reform which are directly relevant to our topic. So firstly, I look at the reform of the UK GDPR accountability framework. And secondly, I look at changes affecting the processing of personal data when developing or using AI technologies. So the current legislative framework sets out a number of specific requirements that organizations must satisfy in order to demonstrate compliance with GDPR requirements. The government considers that these rules may be generating a significant and disproportionate administrative burden and leading organizations to misdirect time and energy away from the activities that ensure the responsible use of personal data in a specific context. To address this, the government is proposing to implement a more flexible and risk-based accountability framework, which is based on privacy management programs. Under this framework, the organizations would be required to implement a privacy management program tailored to the processing activities. The government's proposal focuses on having, in their words, a robust and risk-based approach to data protection management, similar to the approach in other countries such as Singapore, Australia, and Canada. The new proposed accountability framework would require that organizations are accountable for personal information under their control, and it would have to cover three main pillars. It will have to cover the roles and responsibilities within the organization in relation to personal data protection, including who is designated as the responsible individual for the privacy management program and overseeing the organization's data protection compliance. It would also have to evidence that oversight and support from senior management and appropriate reporting mechanisms to senior management are in place. And thirdly, it will have to include measures which assist the designated responsible individual or individuals to demonstrate that the organization is compliant with data protection legislation. So these measures may include data inventories, internal policies, risk management tools, procedures for handling breaches, for example, and so on. Some of these actually, if we think about it, sounds very familiar to the current accountability framework, but obviously the devil is in the detail. So we don't have a draft of the new legislation yet, but we do know some of the changes that will be implemented. So let's have a look at these changes now. So in relation to DPOs, to data protection officers, so under the GDPR, DPOs are sometimes sometimes a requirement to appoint a DPO, and other times they are appointed voluntarily. The role of the DPO and its tasks are regulated under the GDPR in quite some detail. The role of the DPO will be replaced under the new regime by a senior responsible individual or individuals. This role will not be as regulated. For instance, the skills or qualifications required will not be as regulated as they are now, and there will be flexibility to decide these on the basis of the sensitivity of the data processed. But what about DPIAs? The requirement to carry out a DPIA, and there is a requirement to carry out DPIAs for high-risk processing under the current regime. And these will be replaced by the requirement to carry out risk assessments. We don't know yet what exactly these risk assessments will contain in detail, but organizations, the consultation response paper clearly sets out that organizations may still carry out DPIAs if they wish to do so. These will continue to be valid. The requirement to keep data processing records currently set out in Article 30 of the GDPR will be replaced by the requirement to keep data inventories, which will not contain as much information as are currently required under the GDPR. In relation to the requirement of having to consult the ICO if the organization wishes to carry out processing activities, which are high risk and the measures implemented cannot reduce the risk, will be removed. The new regime advocates for having an open dialogue with the ICO rather than make it compulsory, and flags that the prior consultation requirement has hardly been used at all. Changes to the breach notification regime were considered, in particular, to amend the threshold for notification, but they will not be introduced. The proposal was that the notification was only required if the risk to the individual was material, but as I said, this will not be introduced. The government also considered introducing a new process of voluntary undertakings further to a breach, but this will not be implemented either. So moving on to the next slide, I guess the question is, will this make a difference? So in my opinion, it may in some instances, but in others, it may not. And we will, of course, need to see the detail. Maybe it's a bit too early to tell. However, we can draw some conclusions. So it seems that the privacy management program will be based on the same principles as the current accountability framework, and I think it will lead to similar outcomes, especially when carrying out high-risk processing activities. It may also be the case for global organizations who are subject to the EU GDPR as well as UK law, that they might wish to implement GDPR standards across the board anyway, including in the UK, even if some of the requirements are removed or they become more flexible. Let's not forget that the new UK regime will not only apply to UK organizations, but it's likely to have an extraterritorial effect and apply to organizations targeting the UK market. So this is, as Renzo was saying, also relevant to non-UK audience. The government is aware that the introduction of privacy management programs may create additional burdens. When the new regulation comes applicable, organizations will have to review it and work out whether how they comply with it and whether they can reuse existing documents and procedures in order to do so. The government expects regulatory guidance from the ICO on the implementation of privacy management programs, and that this will help remove any uncertainties. Let's move on to the next one. Thank you. So I'm going to be looking now at AI-specific changes in the consultation. So the government consultation has a whole section dedicated to consider legislative changes affecting the processing of personal data in the context of using AI technologies. I will now summarize some of these changes. So the government says that the legislative reforms may allow organizations building or deploying AI tools to innovate responsibly, manage data-related risks at every stage of the AI lifecycle, and ensure that individuals can trust that their personal data is used responsibly. The reforms will involve changes to help organizations use AI tools to interpret existing data regulation, and also it will remove other requirements. The government is planning to publish a national AI strategy later this year, which we should keep an eye out for, as it will also be relevant for data protection compliance purposes. When we talk about the regulation of the processing of personal data or the new regime, this should not be confused with the new AI regulation, which is going through the legislative process in the EU. So let's have a look at, in the next slide, at some of the changes that are coming up. So I will now move on to explain the areas with the government considered for legislative changes. So the first one is fairness. The GDPR sets out that personal data must be processed fairly and lawfully and in a transparent manner. The government highlighted the broad nature of the concept of fairness, and that the concept of fairness is not only limited to data protection, but also relevant in other areas, for example, such as consumer protection, employment, and so on. The government highlighted the fact that there is limited understanding on how to apply fairness, and that there is too little specific guidance, and that the guidance in place is fragmented. The ICO, as part of its guidance on AI and data protection, has elaborated on the concept of fairness in an AI context. And it sets out that in addition to the general fairness requirements, the ICO interprets that fair data processing involves ensuring an AI system is statistically accurate and avoids discrimination in the use of AI for decision making, and considers the impact on individuals' reasonable expectations. The government is concerned about the uncertainty about the scope and substance of the concept of fairness in a data protection regime as applied to the development of and deployment of AI. The government will consider this issue further and has no immediate plans to legislate on this at the moment. The National AI Strategy, which will be published later this year, will explore this matter further. From the consultation, it became apparent from the government's point of view that the issue of fairness in data protection needs to be considered as part of a broader picture. So I'll now consider the issue of lawful grounds for processing. The government asked whether organizations find it hard to identify legal grounds for processing personal data, data reuse, and the processing of data for research purposes. The government asked, should the current requirements change so that organizations can use personal data more freely in order to test and train AI? The government is keen to explore ways in which organizations may be allowed to use personal data more freely. Having reviewed the answers from the respondents to the consultation, the government is not going to pursue any changes on this matter. The next topic I wanted to touch on is bias mitigation. The consultation asked questions about whether the processing of personal data for the purposes of mitigating bias should be included in the list of legitimate interests that organizations may rely on to carry out processing without carrying out a balancing test. Let's take a step back to understand what this means. Currently, under the UK GDPR, when carrying out a legitimate interest assessment, organizations have to carry out a three-step test. Firstly, they have to identify the legitimate interest. Secondly, they have to identify the necessity of the processing in order to achieve that interest. And thirdly, they have to carry out a balancing test to ensure that the interests of the organizations are not overridden by the privacy rights of the individual. One of the proposals of the government's consultation is to set up a list of processing activities which would not require the third leg of the test, so the balancing test. The majority of respondents were not in favor of removing the balancing test in relation to the processing activities carried out for bias monitoring. They thought it would not work and that it, not requiring that test would not work in practice, and this is therefore not going ahead. With regards to the processing of spatial category data for bias mitigation, the consultation asked whether respondents would be in favor of having a new condition in paragraph 8 of Schedule 1, Part 2 of the DPIA 2018 for the purposes of processing, bias monitoring, and correction, subject to appropriate safeguards. The majority of respondents agreed that this would be helpful. The government plans to introduce a new condition under Schedule 1 of the DPA to enable the processing of sensitive personal data for the purpose of monitoring and correcting bias in an AI system. This will be subject to safeguards, such as the limitation to the reuse of the data or the implementation of certain security measures. In relation to automated decision-making, the government considers that the trustworthiness of certain AI systems will hinge on specific design features and effective safeguards like allowing or putting human intervention in place. Under the GDPR, the processing of automated decision-making and profiling is regulated under Article 22. This regime will only apply if the solely automated automated processing activities produce legal effects or similarly significantly affect the individual. Article 22 sets out some safeguards, such as the provision of information to individuals or the right to challenge a decision and request human intervention. The government is of the view that some of the concepts in Article 22 are not clear, such as, for example, solely or significantly affects, and that there is uncertainty about the way in which the article is applied in practice. The government also highlighted that automated decision-making is likely to increase in the future and that the capability to provide human review may not be practicable or proportionate. One of the proposals was the removal of Article 22 altogether, which respondents to the consultation did not accept. Some of them argued that the complete removal of Article 22 would damage the reputation of the UK as a trustworthy jurisdiction for carrying out automated decision-making. So the government will not go ahead with this proposal. The government will introduce changes to Article 22 to clarify the circumstances in which it will apply. The intention is to change Article 22 so that it contains a right to specific safeguards rather than a general prohibition to solely automated decision-making. The government will consider further the approach to explainability and intelligibility of AI-powered automated decision-making, including the role of data protection legislation on this. So I'm now going to move on to the next slide, which relates to other changes.
And Nuria, just to say that you are almost out of time, but do carry on and finish this slide.
Okay, thank you. Okay, thank you. So in addition to the specific section on AI, which I've just covered, I thought I'll highlight some other changes that be coming up as part of this consultation. The first one relates to the reuse of personal data. So, let me just jump to this. So what the government is proposing is to clarify the instances where organizations may process personal data for further incompatible purposes. The government will also legislate in order to clarify the difference between new processing and further processing. And the government will introduce legislative changes to clarify that further processing, when the processing activities are based on consent, can only take place under very limited circumstances. In terms of anonymization, the government is very keen to avoid setting an impossible standard for anonymization. The new legislation will clarify when an individual is identifiable and therefore within the scope of the GDPR. The new legislation will acknowledge that the test for identifiability is a relative one and that the test should be based on the wording of the explanatory report of the Council of Europe's Convention 108+. And finally, in terms of the processing of data for research purposes, there are quite a few changes coming up. The government wants to promote legal certainty regarding the processing of personal data for research purposes in order to boost science and research. Measures that the government will take is the inclusion of definitions of certain terms like research, a new definition of historic research, or statistical purposes. Also, it will reorganize the provisions on the processing of data for research purposes, and it will also clarify what constitutes a disproportionate effort in relation to the exemption in Article 14.5 for processing activities that are specific to research. So I think with this, I will hand over to Martin. Thank you very much.
Thanks, Nuria. Martin.
Thanks, Renzo. Thanks, Nuria, and good afternoon, everyone. I guess, notwithstanding what might come, as Nuria has just been flagging, in this section, I'm going to focus very much on what is a current AI accountability instrument, at least as advocated by the ICO here in the UK, and that's their AI toolkit. So I think, Renzo, you can move on to the next slide. And in the eyes of the ICO, this is a framework for auditing AI and a way to kind of really focus on best practices for data protection compliance. So whether you design your own AI system or implement one from a third party. And this hasn't really come out of the blue, and on screen we've highlighted the development of this over the last few years, and as Nuria said, there's more to come, obviously, with the national AI strategy to follow later this year. And so AI was flagged as the ICO's second technology priority after cybersecurity in their technology strategy paper over 4 years ago. And as it says on the screen, in the quote on the screen, they see data protection and privacy law as being a core component in any broader ethical framework for decision making about AI. And from that initial strategy paper, they've developed a number of publications and guidelines on AI with in partnership initially with the Alan Turing Institute, followed by their own guidance on AI and data protection in July 2020, before they fine-tuned on a couple of occasions and published their toolkit. So we can move on, Renzo, to the next slide. So what does the toolkit do, and who is it aimed at? And essentially, it's a checklist combined with a risk assessment which tries to cover best practice for data protection compliant AI measures. It does try to be practical, and it does try to help align potential risks with real life technical and organizational measures that you can take, ranging from obviously security measures, from encryption, access control, etc., through to privacy notices to support your transparency obligations, considers functionality to help with responding to data subject rights requests, and of course it will touch on the requirement to complete a DPIA, which we'll talk a little bit more about later. The ICO have made it clear that they see this as an optional step. It's not mandatory, and they have indicated that there will be no penalty for not completing the questionnaire. So it's it's obviously at your discretion, but as we'll see, you may find it quite a useful addition to your risk assessment. And in terms of audience, we're assuming that this is aimed at both controllers and processors. Indeed, that was implied in the kind of launch materials that the ICO handed out on when they launched their toolkit, and kind of roughly paraphrase what they say. They said something along the lines of organizations needing to take care to and identify and understand controller processor relationships due to the complexity and mutual dependency of the various kinds of processing typically involved in AI supply chains, end quote. And then specifically, the ICO cites that it's got two main audiences in mind with the toolkit. One, those in compliance roles, so I guess people like myself, DPOs, but also general counsel, privacy lawyers, risk managers, senior management, those in audit roles and the like. And then secondly, technology specialists who they define as AI or machine learning experts, data scientists, software developers, engineers, and cybersecurity experts. So it's a pretty broad range, and certainly having spent some time with it, you could see that that audience, I think, is just about right. And I suppose for an initial overall impression, the toolkit will be familiar to anyone on the line that has a compliance or audit background, rather than even a strictly legal one per se. So a lot of the approach in the toolkit and the structure of the toolkit will be similar to anyone that uses a kind of methodology from anything like ISO 27001. If you're well versed in maintaining risk registers associated with your ISMS or similar, then it's not going to be of any great surprise to you. And so we'll take a look at it on the next few slides. And apologies, this is quite a busy slide, but we did try and capture everything connected with the toolkit and all the various columns in a single page, just for a kind of single reference point. And this is an extract of the toolkit itself. It is an Excel file, and I can almost hear the compliance folks on the call screaming, not another Excel file. But actually, I think if you were sufficiently motivated and inclined, I think the controls that are in the toolkit could be probably applied and adapted into your audit or risk management platforms, if you have any, with the support of your IT folks, to somewhat automate the process. I mean, I do find it slightly clunky to use, and as you can kind of see on the screen, you've got kind of two rows of information to squeeze onto a single slide here. But what we've tried to capture the headlines from the toolkit, plus the first risk that's identified on the toolkit on the slide. So if you read kind of top row, then bottom row from left to right, then you can see the full set of columns for the toolkit on screen. And as mentioned, this is all available to download from the ICO website, and we'll include a link to that when we send out the slides too. And as you can see on the screen, from this initial risk that we've pulled as an example, elements of the toolkit, the Excel sheet, are already pre-populated. So the toolkit covers the 4 AI lifecycle stages, as at least as defined by the ICO, which are business requirements and design, data acquisition, second stage, training and deployment, training, third stage, and then deployment as final stage. Although notably there wasn't any formal lifecycle stage designated for like system decommissioning or data deletion, and that that may be something that follows. And then aligned to those 4 lifecycle stages, you have the relevant risk areas within the UK GDPR on the third column at the top, and then in total there are 32 risk statements with areas to designate appropriate controls to apply to those risks. Plus, the ICO have listed 89 practical steps that can be taken by organizations to help mitigate any of those risks. And again, on this slide, you can see those practical steps. And for each risk area, the toolkit provides additional cells allowing organizations to include a summary of their assessment on the risk, so high level, high risk, low, medium, etc., and gives organizations a chance to describe any practical steps that they will take to reduce the risk. There isn't any specific guidance on how you should actually complete the toolkit, and I think the ICO have recognized that the levels of risk tolerance will vary according to organization, according to their sector, to the technology they use, and the type of organization that they are. And so in the next couple of slides, we've attempted to fill out what we think a typical entry will look like against a specific risk.
Martin, before I move on, actually that chimes nicely with a question just posed, and I think you've just sort of answered it, which is there an example provided by the ICO of a completed AI toolkit for a hypothetical scenario? I guess the answer is no, but here's ours. Is that right?
Exactly that, Renzo. Yeah, so I haven't seen anything that's complete by the ICO, which is one of the reasons, obviously, why we're here today, and we've tried to populate an example. And so on this screen, and over the next couple of screens, we're going to take an example, and I've plucked one of the risks at random. So we've plucked risk 1.6, which is a security-related risk, which is the potential for a data breach around an unsecured AI system. So on this slide, all the columns from the toolkit that are pre-populated, all the columns from the toolkit are pre-populated already, with the exception of the risk assessment summary column, which is, I've tried to put in bold so it stands out a little bit more, and the inherent risk score rating column. So our risk assessment summary hopefully reflects the data protection risk assessment. That is, essentially, there's not enough security around the system. And we've also taken the liberty of adding a kind of linked risk here on the basis that if the AI team don't know about what security measures need to be in place, then chances are they may not know where to go to or what to do when things go wrong. And as the ICO controls on the page state, they want to see some evidence that security is considered from the outset and any risks are documented. So in terms of the risk score itself, that the options there are pre-populated and they are high, medium, low, and not applicable. And on this one, we scored this as a high, which I think, given the lack of security and potential for serious data breach, I think that is probably the right one. But do let us know if you disagree. And then if we move on to the second half of this example, Renzo. So on this side of the toolkit, there was a little bit more work to do for anyone that's filling it in, and in fact, the only column that's pre-populated on this half of the risk or of the toolkit is the practical steps. So those practical steps are what the ICO suggests. So again, maybe jumping back to the question earlier, this is as far as they have gone, I think, in terms of suggesting some steps to address and mitigate any risks that have been identified. So what we've tried to do is we've tried to take those steps on board, and we've suggested a range of our own practical measures in our imaginary organization, which will include things like our organization taking a security specific risk assessment that we would like our CISO, our Chief Information Security Officer, and DPO, Data Protection Officer, to review. We've also suggested that it might be a good idea to get some penetration vulnerability testing on our AI system, and we'd like some specific training for the teams so that they're aware of the security obligations of the GDPR and also what to do in the event that there is a data breach and follow our data breach process. And then so further left we go, we've appointed a control owner for this particular risk, and in this case we've put the burden on our CISO. We've given a new a status update of Medium. So there's on the assumption that the toolkit is going to be an iterative document, a kind of living, breathing document. It's the expectation from the ICO is that this will be regularly reviewed and updated. So there's a status option, again, instead of kind of completed or current or in hand or whatever the options, sensible options would be. They've gone for high, medium, low, and not applicable again. But so again, just to reflect that this is in motion, we've chosen medium. We've given ourselves a completion date of Christmas Day, and we have reduced the risk score on the back of all of these practical steps that we've taken to a medium, reflecting that there are some really good measures here to reduce the risk, but also reflecting that with security, as I think we'll all agree, there's no such thing as perfect, and there's always a kind of residual risk when it comes to cybersecurity. So yeah, if you do this for all 32 risks, you will have completed the toolkit. So it's relatively simple to do, and as I say, anyone that is familiar with a kind of a basic risk assessment methodology, you identify a risk, and in this case, actually, the ICO have gone to the trouble to identify the risk for you. You score that risk. You look at steps to put controls in to mitigate that risk. You assign some owners. You assign a completion date. You then assign a hopefully a reduced risk score to reflect what is done. And I say, we think the expectation, particularly when you think about the status column, that this will be a living, breathing document like any risk register that you currently you're constantly reviewing and updating. And then final slide from me, I think, Renzo. Yeah, so the big question that certainly was asked of the ICO when they had their launch webinar a few months ago was, does the toolkit replace the need for a DPIA? So short answer is no, it doesn't. DPIA is still a legal requirement under Article 35, and for quite a few AI projects, they will probably still need to be completed, as AI tends to hit a lot of the criteria requiring a DPIA. And as we've seen already today, we know the toolkit's optional. But what I think it does give organizations is a very nicely structured checklist and risk assessment for use on AI projects, which should hopefully complement your DPIA and maybe get into some of the AI specific weeds that the structure of a DPIA would not allow you to. So I suppose in conclusion, I think it could be a useful addition to your accountability and AI governance armory. And I guess at this point, then I'll hand over to Chris, who's going to speak about governance of AI beyond data protection.
Thanks, Martin. Chris.
Seamless. Thanks, Renzo, and thanks to Nuria and Martin for the data-focused perspective there. I'm sure your imaginary CISO, Martin, will be delighted to complete the security review on Christmas Day. So moving into the final straight, then, it's now my great privilege to talk to you about wider AI governance. And this is a topic I'm increasingly getting asked about by our larger clients, and I think it's just starting to appear on their radar. I think there's a lot of material being created and there's a lot of discussion about personal data governance in the context of AI, and we've just heard about a lot of that with an a UK perspective. But there's less noise, I think, about other aspects of AI governance, but it's going to be just as important to get that right, particularly if we don't want to fall foul of our various regulators or simply alienate our customers and other stakeholders. So Renzo has moved us onto the first slide, which is why should we care about AI governance anyway? Well, beyond us wanting to do the right thing for our customers and other stakeholders, there are about 30 million reasons, I'd say, to put in place good AI governance, and I'll come to that shortly. The biggest development from Europe on the subject is the proposed regulation laying down harmonised rules on artificial intelligence, the so-called AI Act. And one of its key objectives is to take the key competitive advantages to companies that AI can bring, as well as supporting the socially and environmentally beneficial outcomes that we can derive, and then balance those on the one hand with the risks and potential harms to the interests and rights that are protected by EU law on the other hand. And the approach taken by the EU is to take a top-down big bang approach using a single instrument to try and establish a risk-based regime. It takes what it perceives to be the most serious potential threats and prohibits them, introduces risk management controls on less serious but still high risk AI systems, and puts transparency requirements in place for others. And then it also seeks to put measures in place to support innovation, as well as to encourage the development of voluntary codes of conduct for AI generally. There are also some big fines there for non-compliance. It requires providers not only to comply with the law, but also be prepared to demonstrate compliance with the law. And those fines for failure are to meet the governance requirements set out. And that's the 30 million reasons I mentioned. So 30 million euro fines, or 6% of global turnover, which those of you who are familiar will notice that that's even higher than potential fines under the GDPR. In the UK, it's unlikely we will see a European-style AI Act, and instead the UK will look to revisit existing legislation and pursue incremental reform to regulation at the sector level. There's now an AI assurance roadmap for regulators, which brings together techniques to manage risk and compliance from various contexts, such as impact assessments, audits, independent verification against standards, essentially to deliver a toolkit to select from when determining what degree of verification of conformance is appropriate to that regulator-specific context. Talking about regulators, there's a new Digital Regulation Cooperation Forum, and that comprises the CMA, the Competition and Markets Authority, the ICO, the FCA, the Financial Conduct Authority, and Ofcom, the telecoms regulator. And they've recently been consulting on how to regulate both for the benefits and harms of AI, as well as regulating how AI should be audited. Separately, not part of the DRCF, but separately, the MHRA in the health sector is also looking at how AI should be regulated as a medical device. So the sectoral regulators in the UK have been quite open about the fact that they expect appropriate governance and oversight, and we would therefore anticipate them to put in place governance requirements and hopefully some guidelines on that topic. Next slide, please, Renzo. So next, how likely is it to affect me? Well, the degree of governance that's advisable is really going to depend on what your organization is doing. For example, will you be creating AI and providing it, or will you just be using it? How many AI systems will you be deploying? Are you going to be using them internally or externally? Or perhaps externally with customers, but not externally with other stakeholders like prospective staff? Will they be processing personal data? Will that data be special category data? Or perhaps it's not personal data, but it is commercially sensitive. Are they going to be making decisions affecting people and we just heard about the proposed changes there from Nuria. And then are we proposing to put these AI systems on the market in the UK, in Europe, in neither, or in both? Next slide, please. We need to consider what purpose it's going to be used for. So for example, AI used for any of these purposes is likely to require a higher degree of governance. And I've sort of grouped these down into remote biometrics, where we're remotely identifying a person, whether in real time or after the event, making decisions, so things like evaluating creditworthiness, aiding in recruitment, deciding who to promote or who to give certain bits of work, and similarly in the student context, deciding on which students should be accepted, for example, onto courses, verifying authenticity, so checking travel documents or detecting deep fakes. And in public services, so if it relates to safety, particularly in road traffic or supply of water, gas, heating, electricity, determining access to public services, or if it relates to law enforcement, immigration, or the judicial system, then we can expect there's going to need to be a good amount of governance in place. Moving on to the next slide. Further, or in the alternative, if it's being used in a riskier context, then you might be looking at greater compliance obligations. So in particular, medical devices, radio equipment, lifts, toys, personal protective equipment, machinery, and so that includes sawing machinery, metal presses, machinery for underground working, trucks incorporating a compression mechanism, which I can only assume is things like bin lorries, vehicle servicing lifts, and devices for lifting people or goods more than 3 meters, marine equipment or recreational craft, motor vehicles, trailers, equipment and protective systems for use in potentially explosive atmospheres, civil aviation, security and unmanned aircraft, and then pressure equipment such as pressure vessels, piping, and safety accessories, agricultural and forestry vehicles, cable installations, and rail systems. Cable installations is cable cars where you're pulling people along by cables. So yeah, quite a few sectors there that might be affected. Obviously not relevant to many, but savvy observers will have noticed that the last two slides are condensed down from the EU's AI Act. But of course, we're anticipating sectoral specific regulation both in the UK and elsewhere, so we can't treat these as an exhaustive list, though I have set them out on the slide relatively exhaustively. So let's move on and consider what organisations should be doing now. Well, ACT, I think we should be doing something now. It's worth noting that we do have an emerging degree of clarity around what's going to be expected at both national and international levels when it comes to compliance. We're already in a position to advise clients as to whether they may be caught by particular regulatory regimes, for example, the AI Act, and what the implications of that are likely to be. It feels to me right now a little like it did just before the introduction of GDPR. If you think back, we knew that new rules were coming, as we do now, and we know that businesses need to comply or face those very substantial penalties, those 30 million reasons that I mentioned. Last time, I think far too many organisations left it too late, and that resulted in a panicked compliance activity at the last minute and increased costs as a consequence. And I can feel the nods of assent coming at me through the ether. I think that's probably a shared experience for those working in this sector. My suggestion would be to start thinking now about what's required for compliance and planning ahead to have measures in place in a timely manner. What do I mean by this? Well, I think the first thing is to understand the scope of the development and use of relevant technologies, both now and in the near and medium term. The most pressing need, I think, is to have the right governance structures and processes in place, ready to go. That also means looking at your organizational values and thinking about how the use of AI and the associated digital ethics considerations fit into the organization that you aspire to be. I'd also be looking at your various business lines and seeking to understand current and anticipated use cases for AI that each one is going to want to deploy. It's interesting, having just heard from Nuria, to see the similarities between our thinking when it comes to AI governance generally and approaches to data governance expected by the ICO in relation to AI. I think governance measures that are going to be prudent for enterprises using AI are likely to include things like nominated persons accountable for AI governance, similar to a data protection officer. And I note that was one of the one of the towers that Nuria mentioned. Digital ethics policies, informing development methodologies and procurement approaches, and then flow down terms and codes of conduct for vendors, carefully crafted customer terms, particularly if we're a provider and we're expecting our user to use our AI systems in a particular way, because there's a risk aspect there. We're going to need established risk approaches for both internal and external use of AI, because there are going to be different risks involved, and incident management processes in place addressing what's going to happen when things do go wrong, because they will. We're going to need updated information security policies. We might want to look at things like cyber risk insurance and see what financial coverage we can get in relation to related risks. And it's quite possible we're going to need some sort of AI catalog to manage and track the business's AI assets and record the regulatory status of the various AI systems. Explainability statements, DPIAs, impact assessments for AI systems, those are sort of covered a lot within the data governance. Those are going to have to be balanced with the relevant business cases, as you would expect. And then, of course, any additional specific mechanisms that we need to enable compliance with the AI Act, should that apply, and any other requirements from sectoral regulators. So hopefully that gives you a flavour of AI governance beyond data protection. That's all I had to say, Renzo.
Oh, thank you very much, Chris and Nuria and Martin. So we have some time for questions, and two have come in, I think, which I'll ask to Nuria and Chris, and not necessarily in that order. But just to remind people, we've got a few more minutes. If you've got some questions, do put them into the chat function whilst I show our faces so you can see what we look like. So Chris, the first question then for you, just a bit wider than governance actually, but beyond the need of putting in the governance structures that you describe, what else should organizations, compliance, legal teams, GCs be thinking about as they begin to develop or deploy machine learning?
That's a good question. Actually, it's quite. I'm quite glad that you asked me that, because I was actually talking to one of our clients the other day about exactly this. So there's an ongoing consultation about IP, but actually, funnily enough, we've just had some further feedback from the IPO, but UK IPO. But actually, that's not at the top of my list of concerns. I think the one other thing I'd be talking about to the board would be the new National Security and Investment Act 2021. So that came into force at the start of this year, and it gives the UK government quite broad powers to intervene in investments in certain sectors. So if there is an investor that's going to exceed a certain threshold in a target entity, where that entity is active in one or more sensitive sectors, which includes AI, will need to seek prior authorization from the investment security unit before completing their transaction. And I think those thresholds are 25, 50 and 75%. And any transaction that's subject to that mandatory notification requirement but is completed without approval is treated as void from a legal perspective. So fairly significant consequences. And buyers can also be subject to both criminal and civil penalties. So the fines go up to 5% of worldwide turnover, or £10 million. And there's potential imprisonment for individuals of up to 5 years. So in relation to that, I think there's going to be a need to consider first whether notification is necessary, and then second, whether the documentation for the transaction needs to provide for it. So do we need to put a clause in saying that completion will only take place if and when the transaction has been approved by the ISU? The other aspect and the final thing I'll say about it is parties need to consider the knock-on effect of notification on the transaction timetable, because they're going to have to wait for up to 30 days for the ISU to confirm that no further action is going to be taken. And actually, if the ISU believes that there does need to be a review because it has national security concerns, then the period for review could extend to as long as 21 weeks. So I'd definitely be alive to that one.
Thank you, Chris. Very interesting. Nuria, so one for you on data protection. Do you think that the reuse of personal data to train AI models is going to increase? And if so, is there going to be pressure to authorize such use without explicit consent? I guess they mean without the need to get explicit consent from individuals.
Hi, thank you, Renzo. I think it is going to increase the reuse of personal data, just because to train models. Just because I think this is these type of AI technologies will be more used in the future. So the answer is yes in that respect. In relation to the requirements in order to be able to do so, I think we'll need to see what the final what the bill says, and obviously what the final amended regime sets out. But certainly there seems to be an awareness from the government, and not only in relation to the reuse of the data, more generally in relation to AI processing activities, to allow some more flexibility. So I think that might have a knock-on effect on allowing certain processes of personal data more flexibly in comparison to the existing regime. And as I said earlier, it might be that the government is going to legislate on the processing of the instances under which you can process personal data and reuse it for incompatible purposes as well, even though it might be some limited. So I think the bottom line is, I think it might be the direction of travel. There's certainly going to be some requirements that are going to be more flexible.
Yeah, indeed. I agree with all that. And of course, all the reforms that you mentioned, just to reiterate, I mean, they all overlap with each other. The rules on anonymization and making clearer, or maybe reducing the threshold for when something is anonymized, permission for research, which, in a nice, in some people's eyes, if not everyone's eyes, would include, improving a product for commercial purposes. These things all overlap. And one thing actually that occurred to me as you were speaking, Nuria, earlier, was on the use of bias mitigation and the introduction of a condition, of course, that apes what's in the AI Act, where if you're using special category data, you automatically says AI Act, which I've got in front of me, Article 10(5), you fulfill an Article 9 condition. So basically as an amendment to GDPR to allow bias mitigation. Is this the UK copying EU legislation? One wonders. Perhaps not. Time for maybe one more question. Actually, Nuria, for you, it's a bit unfair because I'm reading it out the first time I'm reading it. Have your clients gotten around controllership issues associated with processors feeding their AI ML algorithms with controllers' data? Yeah, they're old chestnut, Nuria. Can a processor use data which they've got on the processor hat for controller purposes?
Oh my goodness. How long have we got? 2 minutes. Yeah, I mean, I guess depends who we could ask the Canil this question, but I think that this is actually, it's interesting this question is asked, because in a previous version of the slides, but I removed it in the end because, as you all noticed, I overran a bit. I was going to talk about the fact that the consultation did not cover this controller/processor tension in the context of AI, and the ICO has set out in its guidance that it's going to publish further guidance in relation to this, especially in the context of cloud So I think that, this is one of those areas which is, I think, bearing in mind the time I have, is subject to interpretation. But in my opinion, in many purposes, if you use AI for your own purposes or for developing your own products, you are very likely, whether you want to, position yourself as one commercially, but you're very likely to fall under the controller bucket. So,
you are, and therefore, and just to cut you short because we're out of time, you need permission. Or you need to take a risk. You need permission from the controller in order to do it.
Of course.
You need somehow to give notice to the individuals, which is going to be difficult, if not impossible. And you need a legal basis, which is going to be probably impossible if it's special category data without explicit consent, but possibly legitimate interest if it's not special category data, Article 6. We've run out of time. Thank you to all our panelists. Thank you very much, listeners, for joining us. Didn't get a chance to answer all the questions, but those that we haven't answered, we'll follow up in email next week or so. As I said earlier, we'll send you slides and a link to a recording very soon. We do try and deliver a webinar every month, but we are taking a break in August because we all need a holiday. We'll come back in September, 20th September. The metaverse and the privacy issues it raises. Leonie Power, Lorna Cropper, Natalie Barnfield, and Matt Gregson, those of you that know some of our team. And in October, it's me again with Alex DeGay on dark patterns and privacy. Thank you very much, everyone, and have a good summer. Bye-bye.